Justice Barrett?
So there's a lot of intuitive appeal to the contract analogy, especially because it's used for the underlying plea agreement. One thing that concerns me, however, is that at least on this question of appeal waivers, I don't understand any of the courts of appeals to go all in on this contract analogy. And
Fair.
It wasn't fleshed out below in the Fifth Circuit. And I think you've had a lot of questions today exploring how there could be difficulties with it. So it seems kind of risky to go all in on this contract thing.
So I guess 3 responses. One, as always, you're correct. It's fair. Only 8 circuits have applied contract law to plea agreements generally, and they're not. I think maybe only the 10th Circuit and the 2nd Circuit has talked about this in terms of defense. So you're just 100% correct. Number 2, ironically, that is the 5th Circuit. The 5th Circuit's rationale for all of this is you can always appeal above the statutory maximum because the defendant didn't get the benefit of his bargain. I mean, that's too broad, and it kind of, it makes the 5th Circuit's decision just not defensible. But they say over and over again that's not what the defendant bargained for. So we've already gone down that crazy, open-ended route, and so
but Judge Bibas wrote an opinion in the Third Circuit that located the statutory maximum thing in separation of powers and said you'd be going beyond the sentence. So just because the Fifth Circuit said this would be beyond reasonable expectations of the bargain doesn't mean that that is, what we would have to say is the rationale for that exception if we accepted it.
I think separation of powers is good. It's just, for the Constitution, you have to get a little more tricky with why that, outside of Article III power for a supervisor, condition of supervised release, that's just absurd, unconstitutional.
Well, and here's another question I have about the contract analogy. It doesn't seem to me like a lot of the exceptions that we're batting around really fall within contract offenses. It's almost like we're trying to shoehorn them in.
I disagree because I've argued 2 cases in the Delaware Supreme Court, and they're all about expectations of the parties, and one side that usually wins is I expected the contract to be enforced as written. The other side has to really get out of it by saying it's so outside the realm of industry standard or so outside the realm that anyone could have thought of, that anyone could have
But what about
foreseen.
the other ones? Like, what's the analogy for miscarriage of justice? Or, that is grounded, I think, in systemic concerns, maybe constitutional concerns.
Correct.
That reflects the fact that this isn't a pure contract between the prosecutor and the defendant, but the judge is involved because the judge signs off on it. But that doesn't map on. And I
Correct.
think the statutory maximum thing, okay, well, maybe we can talk about it. I mean, nobody's really put it in those contract terms. Maybe the Fifth Circuit has gestured that way.
And
but
I think
then let me just finish this
Sure.
part of it. What rationale would there be for us not taking every possible contract defense that could come along, or limiting it to certain ones? I take it you would say no, any contract defense from the restatement would be on the
Justice
table.
Barrett, with all due respect, whatever the government can do, the defendant should be able to do. The government doesn't get to just say, I can only look at 3 principles of contract law and interpreting the contract, and the defendant has a different rule. I mean, that's just whatever Elon Musk could get, a criminal defendant has to be able to get under a contract.
But Ms. Blatt, and I haven't looked at all the cases in which the government is saying that or alleging breach. I know Judge Easterbrook said that before and invited the government essentially to allege that there was a breach when the defendant appealed. But in all of these contract analogies, you're looking at the term itself and asking if the term itself is, say, unconscionable. And you're not arguing here that the term, that the waiver of the statutory right to appeal, that term is not void against public policy.
Correct.
It's not unconscionable. You're talking about one narrow circumstance, which is the application of that term. So it's not really like the contract itself.
Well, so, A, you're absolutely correct in terms of what Justice Kavanaugh said, but in every contract, again, over and over, we cite cases involving government contracts where a third party has to apply that provision. And there's just defenses that apply when the third party goes off the rails. But unconscionability, I think you're right, it's tricky. So the only way we would get there, unconscionability I haven't seen applied. The only way you would get there is in the government's view, this contract literally says, you waive your right to appeal no matter what, no matter how many body parts they remove for you, and no matter what the court sentences, and no matter what the contract says. And all we're saying is, oh, come on, there's got to be a contract defense to that somewhere.
Okay, last question. This is just a factual one. As I understand the record, the district court said at sentencing when he objected to this medical condition medical condition of supervised release.
Correct.
That, listen, if you go and get treatment and they do prescribe drugs that you have to take, talk to your probation officer, and if that's not fruitful, you can come back and see me. Did he go back to see the district court?
No, he just got out of jail, and he now is under an ordered mental health treatment program. Now, there's something slightly comical about that because Mr. Hunter thinks he will go to hell and thinks God has told him he can't take drugs, which is why he doesn't drink. That conversation is going to be a little difficult with the judge. Okay, I really, God tells me no, and whatever that medical manual is says it's indicated. I just don't see that conversation working out too well. But if it does, I mean, I don't know what this goes to, whether you think it's not a violation. Again, if I'll get a really bad law, if all women have to...
No. I mean, like, I just wanted to know, I wanted to clarify that factually that's what happened. Because I do think then that gives him some recourse to go back to someone in the judicial system to ask.
Not really, because if the court says no...
but the court didn't say no here. He didn't go
correct,
back.
But there's... Again, he has a threat of imprisonment if he doesn't take the drug. I mean, that's bad.